smiling. Everybody's got their makeup on. Including me. All right. I want to thank everybody for joining us today. Sean and I like doing these meetings. We do these once a month and try and hit on some legal issues. And I'll just let you know up front, if anybody has any kind of ideas that they'd like to hear about in the future and future months that we'd like a discussion on, please let us know, because we're happy to hear from you and your ideas. In the meantime, Sean and I got to come up with these, and sometimes we struggle a little bit. But I thought this was a good topic here, and it deals with, and we called it "See You in Court: Topics for Discussion," but it's basically some of the top reasons that agents are sued. And if you've ever been through that, and I know a lot of you guys have been in this business longer than me, but if you've ever gone through that, both as an agent or me, I remember going through one as a broker. It's a scary feeling. It's gut wrenching. It's very time consuming to prep yourself for a case. It's very costly. And our goal is to keep you out of that situation, is to keep educating you, and hopefully that someday you'll never have to deal with this. Okay. So let's get started. And Sean, do you just want to get started on this? You want me to keep talking, or how you want to do this?
It was just, and it's a heavy subject, but just lightening it up a little bit. Some of you may have heard me say this too. And you know that anytime somebody whispers to you that they're going to make a claim or whatever, just come to us and talk to us, because I like to say, bring me your bucket of mud. I've got the water, we'll thin it out and spread it around. So it's like, tell me what you want the answer to be. Let's thin this out. Let's figure out where to place different pieces of this so nothing falls on one person, because you guys are all good, ethical business people. Much of what we're going to talk about today is misplaced. It's misplaced when somebody gets disgruntled, even though, a year down the road or something over, and they're looking for somebody to blame. So then that's when we come in and we spread the mud around, like I like to say. But so, they're serious topics, but we are largely a company full of good, tight professionals who run good business. But anytime you start to get a little nervous about something, come to your management team. We'll help you figure it out, because when you get in the middle of it sometimes, or somebody has intimated that they're frustrated with you, like George said, our human nature, especially when we're good, ethical business people, is to tighten up, and you can't always literally see the forest for the trees. And there's oftentimes so many ways to look at something to diffuse it before it gets into a serious matter. So there's just my 2 cents. Go ahead, George.
Sure.
Sharon's raising her hand real quick.
Just like Sean's saying, I mean, even if you just hear somebody indicate that they may sue, or another agent that may sue you for any reason, a client or a buyer on the other side, go to Sean or myself or any of your management people and let them know, because we'd rather know from the very beginning. Don't wait until that process starts. Let us know from the very beginning, because we'll start prepping ourselves already for it. And that gets us prepared. We can do our research, reach out and find out information and so forth, so that we're well prepared for it. Okay. Mm-hmm. Let's go over the first one. Let's talk about fraud. Okay.
Sharon CEO raising her question real quick. Sharon, I think you're muted.
Go ahead, unmute yourself.
There we go.
Can you hear me now?
Yes, ma'am.
Also, in terms of going to the management team, if you have issues and maybe you think you should pursue them from your standpoint, some things that have happened. I know I've talked to both George and Sean, and they've had enough experience. Sometimes they say, you know what, you're right about what you're saying, but it's not worth the battle. So sometimes it's just good to have that discussion before you get like all fired up. So, and I don't need to get into any specific cases, but it's just good to go to your management team to talk things out. I have found that.
Thanks, Sharon.
Uh-huh.
And Sean, John made a note. He just posted something up there. Curious about what E&O covers and what it doesn't. I didn't have that on my list of things to cover, but you may want to touch on that a little bit, because you deal more with that than I do.
Yeah, and it's and having just renewed our E&O policy, and that is the time when we read it even tight. Well, we read it tight when we get in trouble for something and when we renew, when we're making sure that the coverages in place are as comprehensive as they can be, because we like to flush that out pretty thoroughly when we're talking with our representatives. So the thing to remember with E&O insurance is it covers just that, errors and omissions. So if there's anything fraudulent, and the thing is that we're singing to the choir here, because we're preaching to the choir, because you guys are so ethical. This is far removed from your psyche. We don't dream up some of the stuff that you guys bring to me that other people out there are doing. We would never do it. But the biggest and worst things are the misplaced anger or frustration that somebody throws your way over nothing that you did wrong, but we still have to defend it. So the thing is, it covers errors and omissions,
Hi, little
not
kitty.
anything to do with fraud.
Hi, little kitty.
All right, somebody off a cat or something.
Somebody with
Yeah,
the
Can we mute people who are
Yeah.
not speaking?
So Grace,
George,
it's not your
George, you're
cat.
gonna have to mute everybody.
Okay,
Okay,
see if I did this.
George, you're muted. There we go, George. There we go. Okay.
Okay.
Thank you.
All right, let's talk about fraud and what fraud really is. And fraud is basically is so much of it, it's an element of intent. But when you're blowing things out of proportion, say for instance, and I'll just use an example. Let's say even if your client comes to you, you're listing a home and the public record shows 1,250 square foot of living space, and your client comes to you and says, no, it's really larger than that. And there's nothing justifying that, and you advertise it that way, you could very well be fraudulent in what you're doing because you're exaggerating something. You're telling somebody, you're trying to sell something that isn't really true. That's being fraudulent. Sean, did you want to touch on that a little bit?
And actually, yeah, we've had that kind of claim, and we were able to squish it because our agent had done nothing wrong, but somebody made the claim that our agent misrepresented square footage, and they didn't. But yeah, that is one that will surface, not often, but it does. I've seen it.
And it's also if there's anything you know about the property, there's certain issues with the property, there's things dealing with zoning that you know and you don't disclose, that can be considered fraudulent. It deals a lot with disclosure. It's knowingly not telling even the other side of certain conditions of the property or permit issues and things of that nature. That's all fraudulent. And that's a pretty easy one to understand. And that's really the research I did on this, that's the top reason agents are sued is because of fraud. That comes up as number one as the reason that they're sued.
And it's so broad, if you think about it. To accuse somebody of fraud is so broad, it's kind of an easy target, because it can be subjective to the people's opinions within the transaction. So like George is saying, we owe fiduciary and loyalty to our clients, but not at our own peril. So we've all probably had that situation where a client wants us to present something a certain way and do a gut check. There's nothing wrong with, like I say, if you list a house and you want to put in the comments, the back half of the house burned down, you won't see that in the pictures, just disclose it. Just put it out there, make it be the other side's decision to make. There's no reason, especially in this market, to not be so transparent. And we are, that's it. We're doing this as a reminder and as an enlightenment of the things that we see happen. But we are a good ethical team here. So it's just that, like I used to tell my kids, it's not you I'm worried about, it's the other people in the world. So just be careful and always protect yourself. Don't put yourself in a position of peril to make a client happy.
You're going to find a lot of these topics that we go through are almost interconnected. It can be, even if once we start talking about disclosures, again, you're getting into fraudulent material and so forth. And it's a real hot button in today's world, especially, some of the things we're going to cover, especially in today's very difficult market. Misrepresenting facts and things of that nature is fraudulent. Misrepresenting even your client's status can be considered, financial abilities and things like that. Are you being fraudulent in what you're disclosing to the other side? Okay. Anybody have any questions with any of that so far? No? Okay. Breach of duty is the next one. Breach of a contract, so to speak, but breach of duty. The duty to act in the best interest of your client. That's a fiduciary obligation. You're representing a certain party, and it's your responsibility to represent them to the best of your ability. And sometimes agents will cross that line because they start looking after their own best instead of their client's best. There are agents that get involved in transactions, maybe that there is, let's say, for instance, they're representing the seller, and it turns out to be a pretty good opportunity to invest. And maybe the person that's investing is the agent's brother-in-law, friend, whatever it might be. And they're really looking after that person and trying to create an opportunity for them and not looking after the best interest of their client. So they're in breach of duty. Has anybody ever experienced anything like that? No? Go ahead, Sean.
I haven't experienced it. I would just say I have, I guess, been in a position where it could have happened to me. And I'll just share with you, like I bought a house from a client one time to rehab and resell. And the house was just a mess. It was a worse mess than I thought. But just to protect myself and to be fair to her, I not only showed her a market analysis of in its current condition what it would sell for, and offered her probably like $8,000 higher, but then I had her sign off on what it would sell for if she fixed it up, what I plan to sell it for. And so that was my effort to protect myself. Even though I knew this client, I didn't want there to be any misunderstanding later. So if you're doing those things, you can do them as long as you fully disclose. And I would just say, keep good records like that so that it couldn't be called into question that, well, you told me verbally, but you didn't tell me what you were going to do. No, I had her see the whole place setting and sign off on it, that this was what I was doing. This was my plan. You could have done this, but you're not able to, and you're willing to not do that. So just documenting yourself through those kinds of things. If you're representing somebody, especially who's related to you, or you might have a benefit by it.
A lot of times when I'm involved in conversations with my clients, and I feel that there's something that's very pertinent that I need to be careful of. I got to watch where I step, say, for instance, or it's information that I even told them, or I'm telling the other side, just to make sure that they understand. I make notes of that. And in my loop, I actually create a folder in there called Notes and Communication. And I'll type it up and I'll save that in there as a PDF. I might do it on Word and then save it as a PDF and put it into the loop. And I try to look at it from a standpoint that if Sean or anybody ever has to go into my loop and I don't happen to be here, but a complaint comes in, she can go in and look at all my notes and see what's transpired. And even communications, when you're negotiating, something's gone wrong and you're negotiating with somebody to get it resolved, you keep notes of it and keep it in there so that if we ever have to do any research, it's available to us.
That's a great idea, George.
One of the examples they gave, and this is a brief statement, it says, my agent breached her duty by purposely not disclosing the seller's dispute with a neighboring property owner over the water rights. Now, this evidently was something dealing with waterfront property, but it's something that most people wouldn't think of because even if you're representing the buyer, but you know something about whether it's zoning or whatever it is of the seller's property, you have an obligation to inform your client and educate them.
And that's a touchy subject. because I hear you as far as zoning goes, because that's factual matter. And I've had this conversation with Richard a few times, one of our counsel at Monchower, Miller and McGrogan, because we've had a couple of instances where, for instance, and you know, I'll never name the agent's name, and in this case, I just can't remember, but we had a situation where we had a listing, and somebody within the block said, hey, over in that house, that wackadoodle over there likes to look out the window with binoculars at the children playing in the yard. And the question came to me, should we disclose that? Is that a potential now known fact? Well, was it a fact? Did we know any of the circumstances? Were we going to potentially damage our own client by making a supposition that had no basis? And that was a touchy thing. Like, it went from me to Alex to Richard, because we were a little bit concerned about what do we disclose, but not at the peril of our client if it was not a known fact. So it's like George says, if it's a zoning matter or something like that, and it's public knowledge that we should know, you know, I tried to look up that house and everybody who lived there, and did they have a criminal record. We did the best we could to know. And then ultimately the answer that came from Richard, and I've had two situations like this, were if you don't know for a fact and you don't know what you're saying, you cannot besmirch that person's house, whether it's your seller client or your buyer got wind, and now you're going to jeopardize that seller because you think you've heard something. So that's a tough one. It's tough to know when it is speculation, hearsay, opinion, disgruntled neighbors with each other throwing mud, literally or figuratively. It's tough to know. So, you know, come to your manager with that one, talk it through, and we'll help you if you get into one of those kind of situations.
Yeah, and we did, if I remember correctly, Sean, there was one, I think it was last year or the year before. Remember, we had somebody that was representing a buyer, and then our agent went back to that house at one point, and the next door neighbor came up and started telling rumors about this, and this.
Yeah.
That's rumor. That's exactly what that is. I mean, you might want to try and substantiate something by doing some research, but it's rumor at that point. You can't just go back and make claims.
Right. Right. So we get put into that situation, and then you kind of freeze in the headlights because what do I do with this? Like, so yeah, it's just chat that one through with your managers or any person on the management team, so we can kind of like just talk the logical points through it to try and determine what our best action or inaction is.
Okay.
Question,
Mhm.
George,
Yes, ma'am.
going back to your notes, you're talking about making notes when Chuck said the hair on the back of your neck stands up. You're not just talking about taking all your client notes and sticking them in dot loop.
No, I don't create a book.
Well, that's Chuck's question.
No, Chuck, he doesn't. I see him over there typing. He doesn't have to create a book. It's just sometimes if I know that something that, you know, maybe I look beyond and say, what could be? This could happen to be a major dispute of some sort, or if there's starting to be a dispute of getting out of the contract, and you know that there may be a dispute over the return of the earnest money deposit, I start keeping a log of correspondence at that point.
Okay, thank
Does that
you.
make sense?
Chuck? Yep.
Okay.
Perfect. Okay. Yeah, I don't want everybody going out and writing books. I know I tend
That
to.
would be fun in our downtime, though, to read. Yeah.
Failing to disclose property defects. Another big issue, and we have dealt with that in the past. We have dealt with that probably in the past few years. We had a situation where just that. And this is especially if any of you are investors out there also and going in and rehabbing homes, and then you go out again as agents and relist that and sell it, you know, there's even more areas of concern there about disclosure of facts, defects, and so forth. But we have an obligation to the general public, because there was a situation last year that one of my agents came to me and a home inspection was done. And our agent was representing the seller, and they submitted the request of repairs. Our agent contacted the seller, and the seller says, I don't want to see it. I'm not doing any repairs, and I don't want you telling anybody what's wrong. And the agent felt that he had to follow the instructions of her client, which isn't really the case. That you got material defects there that we have to disclose by law, and there were some there. And the whole conversation was, I thought I had to follow the instructions of my client, and you do in many cases. But we also have, that's above that is the law that we have to follow, and that is even above the duties to the client. It's like, if you know lead paint exists, you got to disclose that. Okay, you know about certain cracks that maybe are structural integrity issues, mold in the basement that's been painted over. You see a wet ceiling, then you're going through a listing appointment, you see a stain, and the seller says to you, says, well, I'm just going to paint over that. Well, does it still leak? Maybe, but they won't see it.
Something to keep in mind along that line too, if I can just insert this real quick, is, we have we all do our paperwork mostly now through dotloop. So it's easy to try and assist a seller, even if your good intentions are, you're on the phone with them, asking them the answers to the questions on like the seller's representation form that we have, which is not mandatory, but suggested. And it's suggested for this kind of protection. That you not, in an effort to help your client, don't be the person who fills in the answers to that seller's disclosure form, our form, not the Maryland form, because you think you're being helpful, but if something push came to shove and in your good intentions that went sideways or sour, and we are asked to produce documents and the history in dotloop shows that it was you who clicked which boxes were going to be answered, that client could potentially bail on you or say, I didn't answer it that way. So a thought to do that is to send that form to them, have them fill it out and scan it, or set it up with the radio dots that they can answer. Don't be the person to answer, even in an effort to help your 80-year-old client, don't be the person to click the answer on that form.
Good one.
Trying to read some of John's notes here, so bear with me. John has a couple of comments. What procedures to follow in the event that you, as an agent, are contacted by an attorney with questions about a transaction? That's number one. And number two is the mediation clause of the MAR contract. What agents should understand about it when reviewing it with their clients?
George, could I ask a quick question of Sean?
Sure, go right ahead.
So Sean, are you saying that when we do a listing presentation, we should have the seller fill out that seller's representation 4 pages?
Yes, ma'am.
I don't think I've ever heard that.
Oh, yeah.
It's just, these are the things that cross my mind. These are, like I always say, brought to you by all of our population who has had something happen to them. So like I said, I never would share names or addresses because we've all had one that we wished hadn't been in our rearview mirror. But it's just the potential for someone, even if not your client. Let's say the other side says the seller should have disclosed this. And, in my world, I think I'm the what if person. I'm like, my mind just goes like backwards 10 steps. So what if something goes sideways on that? And let's say the seller is not available or doesn't recall that they told you to put that answer on that form. And you're asked who filled this form out. The potential to say that you made a mistake in answering it different than the seller told you to just involves you on a level. Let's keep it out of it.
Okay,
We've all done it. We've all done it.
Yeah,
Just sitting
all the
there,
time.
either sitting with them and asking the questions. And I've done it myself. But if you think about it, the potential if something goes wrong to have filled in any of those answers is.
I like to think of it in terms of it, and the best way I put it when I talk to agents is, imagine you're the one that filled it out. And then all of a sudden, a dispute about the disclosure comes up after settlement. And all of a sudden, somebody reaches out, contacts your seller, and your seller says, oh, I didn't fill it out, my agent did.
Oh,
That responsibility
Or-
falls on
Or
you.
you're having an estate, when all the estate would be exempt. So let's say you have a seller who passes away in the year between closing and when this happens, and somebody comes forward and that person is no longer even available to back you up. So it's just maybe a good idea to get involved in having them fill out certain things.
Thank you.
So Sean, while you're on the topic of estates, I just want to confirm that this is, so obviously someone selling an estate has not lived in the house and they are in fact exempt from the disclosure disclaimers.
Yeah.
It doesn't mean that they're not included in the contract of sale. What I've always been advised to do is highlight the section that says you're exempt as the estate and then sign the bottom of each page acknowledging here are those
Yeah.
disclosure disclaimers. We know nothing about the property, but please acknowledge that we're exempt because we are, an estate or whatever the case may be, a REO or whatever.
Right.
That is correct, right?
That is correct. I absolutely agree, because
may have
I've
had
had that
that conversation.
conversation with somebody before, but yes, the two-page form should always be completed. And like you said, I love the idea of highlighting why, who the fiduciary is that is exempt. And then that just shows that you're acknowledging the law without
Right.
having to complete the form. And in that case, if I represent an estate or somebody like that, I don't even ask that seller, because to me, our seller's representation form is akin to whether you are or not exempt from the Maryland form. So I would no more ask that seller representing an estate or something to fill that out either. They have
Right.
no knowledge.
Right. They have no knowledge at all.
Yep,
So-
yep.
Okay. I had that conversation with a listing agent recently. So
Yep, you're
making sure I was
on
right.
point. Yes, ma'am.
And even the decision to complete either a disclosure or disclaimer is totally your client's decision. It's not yours. So if you're representing someone, and even if they say, which way should I go? That's their decision. You can't make that for them. As of about 2 years ago, I believe Maryland was the only state that allowed a disclaimer. The states that surround us now, I don't know much about DC, and John might correct me on this, but I do know that and Delaware do not have disclaimers. They are disclosures only. So they have to complete a disclosure in those 2 states. And it doesn't make any difference. I'm sort of a fan of that. I like the concept of that, of doing it, because you're filling out to the best of your knowledge as a seller. And then somebody will always debate with me and say, well, what if my client is the owner of the property, but he's an investor? He's never lived in it. Doesn't matter. I still feel that they should have some knowledge about the property. That's my opinion, for whatever that's worth. But I like the idea of doing a disclosure. But that's not for me to decide. That's my client's. Okay. Here's another big one with me, and I love talking about this one. That's representing clients in unfamiliar territory or property types. We in this location, especially me in Carroll County, we have multitude of agents that are also licensed in Pennsylvania. And I actually have some agents here that are licensed in Delaware. Some of them know those areas very well, and some may not. One thing that made me think about this the other day is I had an agent that approached me that they have a client that's going to be looking in Northern Virginia, and they're not licensed there. And the first thought that person's mind was, maybe I can get a license in Virginia before they go down there and I can represent them. Well, you don't know the area. You might have a license there. We're licensed in all of Maryland. Your license is good for the entire state. But how many of us know about waterfront property, high and low water means, navigable waterways, things of that nature? I have a 45-foot sailboat, and I don't. I wish I did, but I don't. But can I bring that sailboat into this area? What kind of pier can I put out there? I don't know these things because I don't sell waterfront property. So it's great to want to do a $2 million property, but I'm also taking a lot of risk by selling something to a buyer that I really don't know a lot about in regards to that kind of information. And I know even in Ocean City, there are certain properties there, and we probably have some Ocean City agents that are on the call with us today, but there are certain properties over there, condos, that have different type of restrictions. And they know them. I don't, but they do. I can tell you this, there is a condo complex in Towson. The only reason I know this because I took a class on condo disclosures at one point, and then I'm going back a couple of years, but it's the same development, two different buildings, but they each have different restrictions because they're under different condo associations. Same development, but two different condo associations, and they have different restrictions. We've had people that have done things that have given, in these, not anybody in our organization, but have used old documents from condos and given them out. And I know this is a little bit different, but had given them out, and all of a sudden the buyer buys and moves in and finds out that some of the conditions have changed. And now they're obligated to them. And the one that comes to mind is where a person moved into one in Towson, had a dog, and the old document said you could have a dog up to certain pounds. And then when she moved in, she was door got knocked on and says, "You're not allowed to have a dog here anymore," because the rules had changed. So those are things just to watch out for. Don't any
Yeah, in that light, and I've seen this happen sometimes, so just be careful of this. I've seen it happen in that I've had a listing agent try and give these to me and say, disclosure of documents is satisfied. They'll give you the old recorded documents. The resale package, there's no getting around the law of the resale package, current and dated and signed by the HOA or condo. The reason for that is so that the buyer has the most recent version of the documents and the budget and what they can expect. So yeah, that does happen, because I've had agents say to me, here they are, we've got the documents. Well, that's super great. Those are the ones recorded from 1972. We'll get to reading on those. You'll forgive me if we don't sign off till you give me, you're ordering the real resale package, right? So you try to give them that grace, but, and it's not always that the other agent is trying to deceive you. They just maybe don't understand that there's a reason for the most recent package. And not only that, but the resale package, because there are amendments that have happened, like George said, that, might even be more serious than how much your dog weighs, which is serious if you're a dog owner, but that's a tricky one too. Just making sure that somebody doesn't hand you off what they perceive to be the documents and restrictions and covenants and everything's hunky-dory, because that's not. That's why we have to get the real resale package.
And we also have some scenarios of somebody's raising their hand, Sharon.
George, so that situation you were talking about with the dog, that's pretty serious, because I'm a dog owner. So do you know what the follow-up to that was? What happened?
There was a lawsuit against the agent that listed and sold the property, but I don't know the outcome of it. Again, this was from that class I took at GBR, and that was probably about 5 years ago. So
yeah, I was just curious how that played out.
Yeah.
The agent had to take the dog.
We also get into agents that like to cross the line.
I have another question.
Commercial
George?
properties.
George?
And we get into that as well, because you'll have agents that I mean, we're all hungry,
One
and
question.
you'll see an opportunity to go out there and sell a commercial property. It could be a business. What do you know about some commercial is completely different than residential. You got to understand and know when you're buying commercial property, everything that's involved. I've been fortunate enough that I've owned a couple small business myself to know some of the procedures, but I still will not sell it. Any referrals or anybody that comes to me about selling commercial property, I refer to our agents that have the experience in commercial property, because I don't want to get involved in that. I don't want to be the one to get sued because I've done something wrong. Just knowing, again, you got to know everything that conveys. What restrictions are you up against? Can you have the type of licensed business that you want to have there? What are the restrictions to that? Inventory that's involved, everything. And if you're selling a business itself, how do you value that business? How do you determine the value of that? Do you know and understand how to do that? Because you're not selling real estate now, you're selling business. And that's a whole different animal.
I think Jerry has a question.
Go ahead, Jerry.
Back to the condo situation, I would request the condo documents, but sometimes where the condo association has to send somebody out there to inspect the property to make sure it passes all its rules and regulations. Didn't know that, and sometimes you have to do it, sometimes you don't. But one of the things I've noticed is that the majority of the condos, they have to send somebody out there along with those documents being sent to you and sign off that saying everything's acceptable to them. Otherwise, they have to repair it and fix it before we sign off on those condo documents.
Mhm.
Or have an addendum written up stating that they agree to have this completed before settlement. Have you come across that?
Yes.
Yeah, that's all part of ordering that resale package. And yeah, you don't, and the thing is, like you were just saying, Jerry, you don't necessarily, the seller doesn't have to be compliant. It's unless, if the buyer is okay with that, the buyer can even sign off accepting the deficiencies and acknowledging that they'll bring it up to par, but they have to have the knowledge. They've got to have that resale package, not a haphazard handoff of recorded documents that are partially right.
And that's a very good question, Jerry. And keep in mind, that doesn't just apply. What you're talking about, the inspection of the property, doesn't just apply to condos. Think about Columbia, Maryland. If you fall within the confines of the Columbia associations, the village that they're in, whether it's Wild Lake, whatever, has to go out and inspect the property. And then you get a letter. It's a conforming letter. I don't know.
That was really tricky during COVID.
Yeah, I bet it was. I bet it was. Okay, moving right along. Here's another fun one. And I know most of you guys don't do this. Giving legal or tax advice to people. We're not attorneys. We're not tax accountants. We're not accountants, period. We do not give that kind of advice. We're not even supposed to really be interpreting contracts. We got to be careful when we're in disputes with other agents or in negotiations, that's a better word, with other agents, the language we use when we're typing up an email and going back and forth, because a lot of us like to use emails because it's a trail and we can track it. But if I start, as an agent, start saying to you, maybe it's Pat White I'm dealing with, because he's on my screen right now, and I'm typing a letter to him, and I'll say, Maryland law says this, this, and this. And you can't do this, and you can't do that. But now I am interpreting law. Now I'm acting like an attorney. So I'm going to be very careful about those kind of things. Or even as a client's buying something, you tell them the tax benefits and what they can write off and what they can't. Things of that nature. That's outside your parameters of responsibility and duties. And going back to one of the things that John had asked Sean about E&O insurance, remember, and Sean will correct me if I'm wrong on this, when you're acting outside your duties and responsibilities, you may not be covered by E&O.
Correct. That is true. And George, and an example would be too, why I don't even want to use the word discourage. I don't want to use the word forbid, but I want to use the word don't do it. Why we say, please do not negotiate the short sale on behalf of a seller client. Please do not be, well, I know how to do it. I've done 2 or 3. I can do it. It's frustrating, but I can do it. We should not be doing that. We should enlist either RMP can do it, Lakeside can do it. There are other services, but that is so deep and far reaching, and the implications that could happen to a seller because they didn't get all of the information as fully as they could have or should have to know the ramifications of what it's going to mean to them when they do their taxes the following year, or the legal ins and outs, or the rights of bankruptcy and how it stalls certain things. There is so many layers to make sure that that person in that kind of distress situation knows that we cannot begin to, even if you think you have experience, we should not be giving any advice to somebody going through a short sale. So, and the thing is, the beautiful thing is when you enlist one of our partners, or if you have another service, they take all of that on. You're left to just negotiate in the client's best interest with the other parties, and you leave all of that other stuff to somebody who has the proper background to do it. The law firm attached to the title company that will give the right advice that we should not be touching on.
I want to go back to a couple things real quick that John had asked or mentioned on here, John Westman, and we didn't respond to yet. And John, one of the points he made is what procedures to follow in the event that you as an agent are contacted by an attorney with questions about a transaction. And that's a good question, John, because, and I'll tell you my 2 cents and then I'll let Sean kick in. Be very polite and professional, but always recommend that anything legal has to go through our legal department. Sean, you want to touch on that?
Oh, absolutely. Even if a client or the other client on the other side were to say, I'm thinking about seeking counsel, even if they're seeking counsel because they disagree with our client's position. George's question has to do with our protection. I'm getting to that. But even if, like, a client says, I'm seeking legal counsel. We just had one the other day where the agent with Redfin was so far off base in what she was saying. She was doing that bolstering thing where she was saying this, and this, and she was so wrong. And everything in me wanted to tell her she was wrong. And I thought, no. I had to say to our agent, step back. Advise your client that her client is going to seek legal counsel. Her options are to do what they want or to seek her own legal counsel. We can't guide her on what the answer should be. So that. And then if somebody indicates that they're going to talk to their attorney about something they feel we didn't do correctly, we, like you said, George, we are polite and cordial, but the conversation stops. Anytime somebody even intimates that they're going to seek counsel, you should let your manager and then ultimately me know, because even I at some point will stop talking to them, because once counsel gets involved, and I've said this to Alex, I will only sign or do something that you or Richard have told me to do. I won't even talk to other people's counsel, because there's, have we ever run into an attorney who is not representing us, who's out to help us? No. And it may seem like a light set of questions that they just want information. Even if they say, I just want a subpoena, just let us know right away. Be cordial, be professional, which you all are, and just tell them that you're going to have to turn this over to your legal department.
The other point on that goes back to what Chuck was asking a while back. We all get these pit of the stomach phone calls, where something just doesn't feel right. You have a wonderful transaction going along, and then suddenly your client begins to feel differently, sound differently about the transaction. Those are the things that you really start to make notes about, right? So that you can pick it up from the day you first got that call, or this attorney from Dewey, Cheatham, and Howe calls and is very, very friendly with you on the phone, and you're trying to be helpful. Well, that attorney's sitting there with a legal pad and writing down everything you say. So you just be very, very careful, polite, as George said, redirect it and say, we have a legal team that handles all of these calls, sir or madam. Be happy to have you call them.
Mm-hmm.
End of discussion.
Yep.
Don't try to overhelp. It's going to be hearsay on your part, and hearsay doesn't hold up in court. It just doesn't.
Perfect. Very well put, John. Thank you. The second point John made, mediation clause in the MAR contract, what agents should understand about it when reviewing it with their clients and how they review it. Understand that mediation is a way of hopefully solving disputes by bringing parties together and trying to get them to come to an agreement. Mediation cannot award any monetary amounts or anything like that. Their whole goal is to try and do it in a very inexpensive manner and still keeping communications between all parties. They're trying to resolve an issue and do it in a very easygoing way, I suppose is the best way to put it. And anytime that there's a dispute over the contract, that's what you're going to do first, is go through mediation. Because if any party tries to go through litigation first, the courts more than likely are going to read the contract and kick it back and have it go through mediation first. Sean, you want to touch on that?
Yes, and it is in our contract. Some of you have probably seen, if you're dealing with like a relocation company or a bank foreclosure, they want to strike that language because they're not going to participate in it. And I get that question, can we strike that language? You can strike anything that is not illegal as long as all of the parties agree. It's not a great idea, but there are just some who, or if an attorney gets involved, you've seen that happen too. They're saying we're going to strike it because mediation begins when one party requests it. The other party does not have to necessarily agree. So one party requested, and it really is sort of like, I refer to it as the marriage counseling before the divorce attorneys. It's trying to do what hopefully we've already done as the agents and the calm voices in the room, and that is try to negotiate to where everybody gets some of what they want. When that can't happen, then the next step is mediation. And like George said, if the parties don't pay attention to that clause, and the case is big enough and there are attorneys involved, there was one, the Snake House in Anne Arundel County, that an attorney that actually this firm uses for other things represented the seller who was an agent. And it was a rental and the house was infested with snakes. And the popular opinion was maybe burn it down and start over in 20 years. And the buyers did not go to mediation first, and the attorney representing the agent, it ultimately all went to court, but moved it back and forced longer time for discovery and all of that by saying you didn't follow the contract. So if people get hot-headed and they don't pay attention to at least attempting mediation, and it gets involved and there are attorneys, they can push it back and delay it because you didn't take that step. Even if the other party wouldn't agree, somebody did not initiate starting mediation.
Any questions with that? We've been quiet today. Another point going through all this stuff is failing to recommend home inspections, especially when you're working with a client in multiple bids and you have agents that are instructing their clients, is saying, if you want this house, don't do a home inspection or don't ask for a home inspection. That's the worst thing in the world to do. Because again, that makes you liable as an agent, because they are following your lead. You are the person in the know. You are the person with all the knowledge about real estate. That's why they hired you. You're the professional. And when you do something like that and something goes wrong, they move in later and they find all these issues, $30,000, $40,000 worth of issues. They're coming after you because that's something that they could have found doing a home inspection.
I've found with some buyers that if they're first-time buyers, I've experienced this. They'll say to me, well, do I really have to do one because I'm going to have an appraisal? So the client doesn't always understand the difference between a 3 to 4 hour shakeup where somebody turns the house upside down, or the 15-minute set of eyes to make sure if the bank has to repossess the house, that the appraiser is not their friend. The appraiser is not there to help them. They don't understand that difference. So if the client makes the decision, that's one thing, but it's such an important step.
Going through this, I know we're in tough times right now. There's such a low amount of inventory out there, and we're all struggling to get contracts accepted. Clients, just as Sean was talking about, really, they don't understand the contract. They don't understand the whole procedure. And one of the things I normally say when I talk to clients and I interview clients, both buyers and sellers, I tell them, however far-fetched it may sound, I'm not a salesperson. I don't sell homes. What I do is I educate my clients in the process of the real estate transaction. That's what we do. And we do that through communication. We're not attorneys, but we educate them in the process, and we're constantly communicating with them, letting them know what we're doing each step of the way, and we're giving them advice, but not instructions. We're not telling them to do something. We're advising them that this may be a good decision or something like, but it's ultimately their decision. That's always the way you got to put it. It's your decision. I remember sitting in front of Al Munschauer, and he did a role play one time, and the person kept on saying, well, what should I do? Should I do this? Your decision, your decision. How much should I offer for the home? How much should I pay? You know, things, should I do a home inspection? That's your decision. I advise you to do it because it's an important part of the process, but they may not get the home. We all know that. So it's a really touchy situation nowadays, especially when you're trying to go in and buyers are giving the boat away. They're giving everything away just to get a property. We just recently had one out here that our agent, you know, lost out on a contract and was $101,000 over the list price, no home inspection, waive any kind of contingencies, and didn't get it.
Thank God.
Can I ask a quick question now?
This is all going to come back possibly someday and haunt us. Somebody out there is going to be a disgruntled buyer, and that some agent told them, don't do a home inspection. And they're living there a year or so, and they discover this issue. Bang, we got a problem.
I think Ellen has a question.
Go ahead, Ellen.
So we're seeing that now where people are waiving things that seem crazy to us. So obviously on the contract of sale, they are initialing inspections declined, or if they're waiving their appraisal contingency. Is that enough to protect our agents, or do we need something further to back that up?
I personally think as long as I didn't instruct them to do that, I advised them that it was best for them to get a home inspection, and I tell them the reasons why. But they're going to ask me more than likely, well, what are my chances? Chances are, you know, yes, there are people out there that are going in there without doing home inspections, but that decision is yours. As long as I did that, I think I'm okay. Now, Sean may differ with me and say, yeah, it's good to note it somewhere, or it's good in somewhere in your log. Maybe if you're logging things, then make a note that at least you did that. But if you do that as a practice all the time and don't differentiate from client to client, that you're always doing that, you're not going to fail.
Hey, George.
I have a comment on that. Because
go ahead, Tim.
with the home inspections, when they don't want to do a home inspection, that makes me nervous. So, and I always tell them, always recommend you do one. You know, you can find this, especially with septic and well and all of that in there. I always, after we have that discussion, send them a follow-up, a recap email or a text, and just say, you know, this is what we talked about. I just want to make sure that I got it all right, so we're on the same page, and just have them say, yes, okay, submit it, whatever. Just something that they come back, you know, that I have it in writing somewhere.
I think that's the notes situation, George, that you're talking about.
Yep.
Chuck had a question.
It's CYA.
Not a question, but I read an article recently that it said 75%, a study was done, 75% of the buyers in the last 2 years wish they hadn't, in some respect, bought the house that they bought.
Wish they hadn't.
Had not.
Yeah, that's what I thought.
So
75%.
you talk about people coming back on you if something goes wrong, no inspection, something like that. It's a whole lot more prevalent than one would think.
Wow.
You also, Tim was out there. He had a question too. Tim Delaney.
Yeah, what I was going to say was, you know, I never tell anybody not to get an inspection. If they want to do one of these as-is things, always make it with the right to walk. If they decide they don't want that, I get them to sign the home inspection addendum and put right on there that the buyer has elected not to do the inspection per their request. And I just get them to sign off on that, because I'm not going to leave my neck hanging out there.
And I agree. I mean, you all might have different ways of recording that. I like what you just said. I like what Nancy said. I mean, email trails are great. And again, Sharon, what you said, I would definitely put that in my loop. I would put that on notes and communication.
Yep.
Hey, guys, another thing, and I do this, so in my world it makes sense, but when you're creating those documents in Dotloop, the way I do too, to make sure that I have a record, that I have instructed that client to review these documents because we're not physically together, I will write in the notes, you know how you can write, when you send something to somebody, you can put a note on it. I write in there, I'm sending these to you for your review with no ability to sign, it's important to me that you take the time to read without being led, is what I say to them through the document. And when you're ready, let's discuss questions or let me know that you're in understanding. And then I just click view only, and I send the documents to them through Dotloop as view only. And then I make sure that they answer me back and say whether they have questions, like call me, I have questions, or I'm good, send it over. Then at least I feel like I'm documenting within the notes of the loop that I sent it and said, I don't want the mechanism to lead you through this document without ability to read it at your speed. Just worth thinking about if you're not already doing that.
Good. Okay.
Question,
Go ahead. Gary, you had something?
George? I agree. I always wish they would do home inspections, but I'm leaving it up to them to make that decision. But one of the things about this as-is addendum, when you're doing as-is addendum, you're kind of alleviating everything after so many days it's in there, which means you're not going to come back. But one reason I'm talking about is the termite inspection. You can have a termite inspection, but if there's termites in the property, you can't come back and ask them for it because you're basically buying it as is. Same thing with the well and septic. I put a well and septic and send them in the contract, and I have as is addendum, this inspections. That kind of muddies the water a little bit, where I personally would want them to have the termite inspection, and I want the addendum that's in the contract to be able to pursue the repairs that they have to do, and not make that part of the as is. And the same thing with the well and septic. But the well and septic, if I put 10 days in that as is, I'm obligated to do everything in 10 days. What's your suggestion on dealing with the, termite inspection? I mean, one thing is to say, I guess that we're obligated to do the termite repairs based upon the paragraph number 19 in the contract, which means they have to do the repairs up to 2% of the sales price. But I'd have to make a notation, I guess, in the as-is addendum based upon that, and also the well and septic. How would you handle that?
Well, you and I talked about this the other night, and it's a good question, Jerry, because it's more and more people are using this as-is addendum, if nothing else, as a way, almost as a ploy to try and get in and get the house. But it's alleviating, what is it, Article 19 and 22, I believe it is, where it's the condition as the property conveys, what you see is what you get type of thing. And then it eliminates the termite inspection clause in the contract. It supersedes that. It takes it out, basically. And you're allowed to do any inspections you want, but it gives you the right to get out. And you're right, if you put 10 days in there, not only do you have to have the inspections completed at that time, but if you're going to ask for any repairs, which a lot of people still do, you have to do it within that time frame. And if you do it on the 10th day and the seller comes back on the 12th day and says, no, I'm not going to do them, guess what? Your contingency or time period to get out of the contract has expired.
But I think Jerry's point is, and we had this happen to one of your own people, they did as is addendum, and then they said, well, you don't have the right to do the termite. Is that what you're saying, Jerry?
You do have a right to do any inspections. It gives you the right to on any inspections. Go ahead, Jerry.
Yeah.
Well, we've had instances where agents have said, if you do that, everything is as is, and it negates the termite paragraph.
Only if it says it in the document.
What it takes out is your right to ask for for the seller to pay up to 2% of remediation and any kind of repairs of damage. That's what it takes out. You have a right, because remember, it covers all inspections. When you're doing it, you can do termite, you can do well septic, if you can do them in 10 days. But I know, Ron, we talked about this before, if you're doing septic, we like to include that septic inspection addendum because there are certain clauses in there that protect the brokerage and so forth that the as-is addendum doesn't. Sean, you want to, I see you waving your hand.
Yeah, yeah, and Jerry, thanks for bringing this one up because we talked about it too. So by example, when I have had clients, and again, this is my way, so I'm not bossy enough to presume you all do it my way, but I think it's a good idea. I have written on the as-is a separate paragraph that I have all the parties acknowledge. I cross out 19 and then I put verbiage in there that says, in real simple couple of sentences, all parties agree that paragraph 19 withstands and agree to the terms of it. Because especially like if I have a VA buyer, the VA wants, you know, the fences, the garage, the neighbor's house, everything inspected. So I'm just going to set it forth in the beginning that we're 19 is going to stay. I don't like that one being taken out. That could be worse than doing no home inspection, in my opinion, because termites are hidden. And like the damage, in my opinion, I've had a house where the whole front was falling off for a buyer and Terminex came in and rebuilt the whole front of the house. So I think that one, in my opinion, bears putting it out there in a real simple method. It's not about writing law. I'm just saying 19 is still going to withhold. Oh, I lost my train of thought there. We were talking about pests.
Well,
Water and septic?
Oh, water. Oh, yeah. It's important too, if you're doing the as is, like George was talking about, if you're going to do septic, you should include the septic inspection addendum because the as is does not give them the right to excavate the property. So if you're doing any more than opening the cap and sticking a camera down there, if you're doing prodding or excavating to get to a covered clean out, you're really kind of violating that addendum. So the septic addendum should still be included, in my opinion, so you can do your thorough inspection.
Hey, George,
Yes, sir.
if there becomes an issue with the water and the septic, wouldn't that now become a financing issue?
Yeah, usually is.
So would if you can't, if the buyer's unhappy enough that they don't want to continue with the contract, could you make it a finance, all of a sudden the lender gets a copy of that report? And now they're not going to lend on a property that has, a water issue, a septic issue that would affect their rights.
Go ahead, Sean.
I've actually had a VA buyer where that happened with the septic and the lender didn't care. They wanted to make sure they had good drinking water, but they didn't care about the septic. Now, I went and told them because I wanted them to know for my buyer's benefit what their rights were. And the buyer got a big credit from the seller so they could hook up the sewer that was available. So we negotiated it that way. But surprisingly, the lenders do not oftentimes require a septic inspection. So then if you think you're going back to that to report it to the lender, then could you possibly as an agent have stepped outside of your realm and now you have potentially harmed that seller where the contract didn't call for or the lender didn't call for a clean septic inspection? Did you now somehow cause damage to that seller by having the buyer's financing not go through because you interjected something that the lender didn't ask for and require?
That's a tough one.
Mm-hmm.
Somebody asked.
Let's go back to the well inspection.
Hold on, Jerry. Somebody asked, are we talking about the Remax as is addendum or the MAR? I think we're pretty much talking about both of them.
Right.
Go ahead, Jerry.
So, okay, so the as is, let's say you have 10 days to get on inspection. There's no way in the world we're going to do a well and septic within a 10-day period because sometimes it takes 20 days to get them to report back. That if I put the addendum, the septic as part of the contract and put 30 days to have inspections done, does that still, can I do that as is 10 days is going to me to have the work done within 10 days where I can't do the 30 days? I'm saying this as is 10-day period inspection.
Go ahead, Sean, you had your hand up.
My opinion is, once again, Jerry, that, and I get you're trying to protect your client, but in protecting them, I feel like, and George has said this a few times here too, you have to explain the risk and reward to your client and let them make that decision. You need to explain to them you're competing, which is more important to you, because you can get it done. Like there's one company, I won't say that I tend to use, because I do give my clients the ability, but there's a company that oftentimes they choose because they do it all. Like there's a convergence of people on a Saturday morning doing the home inspection, the well and the septic, all within day 2 of the contract. And then you get all of your answers. But at the end of the day, it's up to your buyer client to decide their risk and reward. You're competing.
All right.
What do you want to know? Are you willing to potentially, if you are competing, I think I get what you're trying to ask. You're trying to be competitive in your offer and say, well, if I put 20 days in there, the seller's not going to like that. And I'm not going to be as competitive. That goes back to your buyer's decision. Do they prefer to be more competitive at the peril of not having the answers back in time? Or do they say, I would prefer to lose the house than not have complete answers?
Okay. And one
Well,
other,
I have
that's
a
a loaded-
question along those lines.
That's tough.
Yeah, I have
it
a
is.
question. If you were in that situation and the answers were not going to come back in time, does that give them the right to get out based on inspections because they still don't have their answers? If you give them an answer before the 10, if you back out before the 10 days.
Mhm.
Make sense?
My opinion is yes, because you have the
I don't think so.
unilateral right to withdraw within the 10 days. You don't have to give a reason.
Okay.
George,
Okay.
do you see it that way?
yeah, as long as they do it within that 10-day period is what we're saying. Yes. Even if they don't have the results, you can get out for any reason. And you
Right.
don't have to explain why, technically. You just say,
Right.
as a result of the inspections, we went out.
Mhm.
One other topic with inspections, and again, I've been recently going through a whirlwind of taking my CE classes, and it's amazing what you learn sometimes when you do that. There was a discussion about, or an article about recommending inspection companies, and you got to be careful because there was a case where the agent recommended their company. Now, there was a little bit more involved because the reason they did it, they knew this person, the way they did it, and they weren't real detailed about doing the inspection, and they knew that they would make the contract go through. They wouldn't destroy the contract. I used to hear that all the time from agents. Use this inspector because he'll get it done and the contract won't fall apart. Well, the buyer moved in and covered these issues, and then because her complaint against the agent was because you recommended him, that he didn't do his job, and then there was a lawsuit that, and they found that the agent guilty, by the way.
Mm.
So just a little note about that. They always recommend that you recommend more than one person. Okay. We all finished with that one. That was a long drawn out one, but that's good. This is good information. Going above and beyond the call of duty. I've run into this numerous times. We all want to be everything to our client. We want to do everything for them, help them any way they can. We do this for them. We do this for them. I have one agent one time, not with our company, but one agent explained to me that when repairs were needed, they did the repairs themselves, went in and did the repairs for the seller. They helped. I've had one agent where they helped them move. The agent or the client moved out of state, already had a house in Florida, was down there selling the house up here. The agent got involved, hired the moving company, which happened to be one of those. They put the drop boxes in front of the house, hired the people to load it, did everything, took care of it, sent everything down there, got unloaded, jewelry was missing. They're coming after the agent. That's what happens. Again, it's out of your area of responsibility as an agent. If anything goes wrong, you forget about your E&O insurance covering you. We are realtors. That's what we do. We are realtors. Our job is, and I'm going to go against my own words earlier, we sell homes. That's what we do. We sell the property. Okay. That's all we do. That's what we're supposed to do. But we want to be everything to everybody because we want to be the nice person that they they know they can rely on us. They can come to us for everything. We have the knowledge. That's what we sell. That's what our value is, our knowledge and expertise. That's our value. On any comments?
Nope, that was right on target.
Yeah, I mean, it happens quite frequently. And let's see. The last thing I had on here is things that we want to touch on is we talk about this a lot is turning in the earnest money deposit. You have a responsibility. Forget about what the law says about the time frame that it's turning in, and Sean will get on that. But remember, you have a fiduciary obligation of accountability. Somebody gives you a check. It's your job to handle that responsibly and make sure it gets turned in the time frame that's allotted. What happens sometimes is and it happened to me at another company, that someone never turned the check in. It took, at the time of settlement, they realized that check was not there, that we had an earnest money deposit and it was a large one. Okay. And the check wasn't there. And now everybody's scrambling to figure out what went wrong, and you're at settlement. The other issue is what happens when it doesn't get turned in time and it hasn't been cashed and put into our escrow account, and you have a dispute over the contract falls apart. The seller says, I'm going to keep the earnest money deposit, and petitions to do that. And we don't have it.
Ugh.
Now we're in trouble. Big trouble.
Mhm.
And I know that's one of your favorite topics of discussion, Sean. Go ahead.
I just feel like I need a brown bag to breathe into. No, what George is saying is true. And, now we have that form that we can all use now, the escrow form that is good. It leaves us oftentimes following up with title partners then to make sure that they complete the form, because even though the title company is holding it, that doesn't relieve us from our responsibility of making sure it got where it needed to be. So it can oftentimes complicate our lives, actually, doing it that way, because now we have to follow up with a third party. We're not even responsible enough, or we don't have it within our realm to solve the problem without that third party acknowledging it. So it's still on us to make sure that it got where it was going. And yes, we do have that. We've had instances, and actually the one I'm recalling was our seller feeling violated or wronged and wanting the buyer's earnest money relinquished to them. And even though the buyer's agent saw that their client probably had done things wrong, they never deposited the check. And in this case, our manager went back to their manager and tried to school them on what was wrong. And I got to tell you, it was not a well-known, maybe we know the name of the brokerage, but that agent's stance was, yep, tough, didn't get it, didn't turn it in. And even though his manager / broker said, write a check, he said no. And they rolled with that. So that reminds me, I haven't heard anything more about the outcome of that one, but it is our responsibility as agents, and then ultimately up to the brokerage to get that money in place. And when we don't, there could be repercussions. Sometimes even the buyer then just disappears, especially if it's a smaller deposit, but that doesn't mean that the seller's not going to pursue coming after it. And the bigger the deposit, the more likely they're going to pursue coming after it. So it's important that we have those funds in place, even if they never get relinquished to that other party. If it goes so far as to go through mediation and then the courts, and that money's not there, it's there. It's just not there by the buyer's check. It's there by ours.
If any of you, go ahead.
Sorry, George. I had one. I know we're moving towards wanting the title company to hold the money, But I had a nightmare. I mean, it all worked out fine. I was on the selling side, the listing side, and the buyer changed title companies midstream.
Ugh.
The agent didn't tell me. The original title company sent the earnest money check back to the buyer. And we're 2 weeks before close, and I can't get the new title company to confirm that they've received the check. It all worked out. They got the check, but it was literally like a week before closing that they got the check. And it was like, what do you do in that situation? I mean, it wasn't my fault, but
No.
it was anxiety filled.
And it's funny that you say that, Nancy, because the form is there, and as a brokerage, I'll tell you that there were lots of conversations on the management level about us as a brokerage adopting that policy more strongly and kind of going along that path. And finally, one day, I think we all had talked about it so much, and I said to Alex, I think I can't give you the list of reasons why we should do this because I don't think I agree with it. And we all collectively sighed and went, yeah, you know what? We're pretty sure we don't always agree with it either, because to accept a policy and adapt it as maybe the norm was so many variables, just like you said, Nancy, and letting go of the control doesn't mean letting go of the responsibility. So it really could tend to complicate our lives more, as in your case, Nancy, by having a third party holding it. It's important to know your title company. But when you're on the listing end, even if you think you know the title company, if the buyer directs them, shamey on that title company, they shouldn't have released it, but they did. And, potentially, like you said, you got it worked out. But yeah, we have kind of pulled back a little bit on that because of all the variables of loss of control. We were trying to control something and make it pretty and packaged, and realize in doing that path, we were kind of losing the control.
Yeah, to Sean's point, not only were we losing the control, we were retaining the responsibility.
Exactly.
And that was something that we could not reconcile as a management team and as an ownership team to do for the good of our own agents and for the good of our agents' clients. We just couldn't do that.
Yep.
So I would say that right now, even though there's a movement in that direction, it would have to be, I think the requirements would have to be somewhat different before we'd agree to that.
And that's, to that point, is why it's so important to get that third signature, not only your buyer and sellers. It's so important to get that title company, even when they resist or ignore us, to sign off on that, because then they are accepting responsibility to basically adhere to the brokerage laws and not to let go of that money. So if they did it and that had caused harm to Nancy's client, we would have at least, there we go with that bucket of mud and water thing, thinned it out a little bit to go back to the responsible party holding it and say, why did you do that? So we got to have that third. When it is a title company, it's on us to get that title company to acknowledge it.
Very good. Okay, we're running to the end of our time. Does anybody have any other questions at this point?
Hey, Sean.
Mm-hmm. Yeah, Jerry.
Yes, I do. Often, when you're the listing agent and the buyer's agent has a third party that's going to hold deposit money, and he put in the contract that the deposit money will be forward 2 days of the contract.
Breaking up.
Which means that as soon as the contract is accepted, that has his deposit money to the title company.
Jerry, you're breaking up a little bit there. It said your bandwidth is low. Are you asking, I'm going to rephrase your question. Are you asking us if the contract says that within 2 days of contract acceptance, that money will be to the title company? Are you asking, is that your question? Like, is it our responsibility?
Yes.
Absolutely. Yes, it's our responsibility to verify it got there.
Okay, so so it's okay to have 2 days in the contract to allow the buyer to have 2 days to get the check over to the title company. And
Yes,
then by the second day or third day, we should call the title company and say you got it and get it signed off.
Yep.
That's okay.
yep.
I've had
exactly.
one or two have done that. And I always get nervous thinking I got 2 days away from to get that check over.
Yeah, yeah. But I mean, that's logistics, but then it is critical that we get the title company to sign off.
Yeah, because the problem is that the buyer doesn't want the check unless they know the contract and the title make the check until the contract's accepted, I'm assuming.
No, right, you can't
And
deposit.
that's
somebody's
why
check.
the title company would have to, the contract to get signed. Okay.
Right. Yep.
I'm sorry, I having your time hearing me.
Yeah, it says your bandwidth is low. Something's going on.
Sean,
Yes,
Okay.
I'm not saying we should do this, but let's just take Jerry's scenario where they say 2 or 3 days to give it to a title company. I mean, what if it's not somebody you know, or maybe somebody you're really not comfortable with? Can we ask that the deposit be made to our brokerage, or is that not something we should even approach?
no, you can. I mean, in the form of a negotiation, if there's somebody that you have a uncomfortable feeling with, or the agent or the title company, it's all part of negotiations. You can, it would be your client's request, but based on your experience, you could say to them that I would feel more comfortable. Do you want to consider asking for this? Because then you're looking out for your client's best interest without besmirching somebody else. But yeah, we all have those ones where
I know that could be tricky, and I haven't had it, but my question is, do we have the right to say this is what is preferred? Because you're talking about that loss of control and retaining the responsibility.
Mhm. It's all part of negotiation.
Okay.
Yeah, it's
All
not
right, thank
demand,
you.
but negotiation.
Yeah, I agree with that. And, you know, it's strangely enough in Pennsylvania, the Pennsylvania contract, it is normal and customary that the listing side holds the earnest money deposit unless otherwise stated. Whereas Maryland, it's usually customary that the buyer side holds it, but you can ask, and I've seen it multiple times, that I'll get a cover with the disclosures from another side, and it will state in there that the listing agent or the listing company wants to hold the earnest money deposit.
I think a decade or more ago, it was kind of common practice in Howard County.
It was.
Yeah.
It was.
Yeah, makes sense. Yeah. Anybody else? This was good, great conversation, guys. I thank everybody for attending today. We had about 37 people online here at one point. And I just want to let everybody know that, you know, we enjoy doing these kind of discussion groups, and we're all, the entire management team is always available to you. If you ever have any questions, need any assistance, consultations, whatever it might be, we're all here to help you. I know John and Alex have a very busy schedule, Sean and I and Ellen, all the other managers over on the Eastern Shore, we're all here to help. And we can go back and forth. You know, Sean can answer questions for any agent with here. I can do the same thing. We all work together as a team to help you guys. That's what we're here for, to help you. So if there's any time you ever have any questions, don't ever hesitate to pick up the phone and call us.
Mhm.
And next week on the 16th, we're having a company-wide Zoom. It's the February business meeting, so hopefully a lot of you will be back for that. It'll be good information, a little review of last year, and then maybe some predictions of what next year could look like. And by that time, we'll probably, in the next week, we'll probably have different predictions for what next year could look like. But hang in there, everybody. Great
Thank
seeing
you.
all.
Thank you very much. Yeah.
Take care.
Thank you guys for the time. I appreciate it.